Hello everyone, Keith here, back in the video. Today for you guys I'm going to be reading the 10 things to know about trust, a handbook for a quick understanding of trust. I'll leave a link to this down in the description below along with our email. You can email us at themilliagmail.com for a private consultation. Without further ado, let me get right into it. By Robert A. Cole. Introduction. 1. What is a trust? WEISS Concise Trustee Handbook. First, it must be understood that any trust, regardless of the many designations applied to them, is, in its most basic sense, a property interest held by one person, the trustee, at the request of another, the settlor, for the benefit of a third party, the beneficiary. The classification applied to a trust is based primarily upon its mode of creation, in which it may be created either by act of party or by operation of the law. In the case of a former active party, trusts are divided into two types, express or implied. And you have a graph here, creating trust by active party, implied, impressed, or written. Down it says by act of the law, resulting is on the right, constructive on the left. Black's Dictionary, p. 1513, 7th edition, 1999. An even more basic definition provided therein, the right enforceable solely in equality to the beneficial enjoyment of property to which another person holds the legal title. There are many more subdefinitions as well as expansions upon the nature of a trust relationship, being a fiduciary one, but we won't go into them for want of space. Without getting into the various subclasses of express and implied trust, the basic difference between one created by express act of a party and one created by implied act of a party is that the former express is stated fully in language, oral or written, while the latter implied solely from the conduct of the parties. 2. How is a trust structured? WEISS Concise Trustee Handbook. Express trust is not merely a property interest held by one of the benefit of another like any basic trust. Rather, it is a trust created by private contract by the settlor, for the holding of a divisible property interest, where the trustee is empowered by the settlor to do a beneficiary of his, the trustee's choosing, whatever he, the settlor, may do for himself as an individual sui juris. What has been created here is a trust organization, lawfully by natural right. As a general proposition, it may be asserted that one who creates a trust may mold it into whatever form he pleases, and that whatever one may lawfully do himself, he may authorize another to do for him. Doing so requires no benefit, privilege, or franchise from any government or other outside party, and therefore the parties owe no duty to any government or other outside party to the extent that no common law criminal or civil wrong is the purpose of the contract. 3. Who can use trust? Everyone can and everyone does, mostly without knowing. This would be the second most important reason why we are in such bad shape. Understand that just because a trust is not expressed does not mean a trust relationship does not exist. Look up implied trust. You think about it. Every day we all use currency that is nothing more than a promise. Do we all therefore not trust that we will get paid one day? We drop our children off at daycare and we trust we will get them back in original condition. It is our lack of knowledge about trust that hinders us from seeing trust relationships, much in the same way that someone who has never heard of straw men doesn't recognize an all capital name for what it is. The wealthiest people on the planet use trust. It is how they hide wealth. They settlor control everything. Property reads in trust terms, while owning nothing. control to a trustee, and they enjoy the benefits, beneficiary. Their knowledge is what makes them creditors and not debtors. Now, do you see why trusts are not mentioned much? It's one of the best kept secrets. 4. Why should we learn about trusts? This is how I came to understand why trust knowledge is so important. Many people focus on contract law and in particular contracts that involve the exchange of currency. For a contract to be considered valid, there needs to be a meeting of the minds. Full disclosure, equal consideration, and it must be lawful. No contract such as to kill someone. In case of a loan, you agree to work, which is value, to repay a loan of currency, which is not backed by anything of value. So where is the equal consideration? There is none. Since the gold standard has been removed, where was I? Since gold standard has been removed, there hasn't been any. The banks know this, and they also know that there is a trust relationship has been formed. They prey on our ignorance. This is why I believe if you challenge a bank's contract on the grounds of validity and then state that they do not reply, they agree it's not valid. You never get a reply. Of course they agree. They are telling by their silence that you are correct. They just don't tell you, and honesty is not their obligation. That what they have been calling a contract is actually an asset property, your property. Then you hand it over to them without giving them any instructions on what to do with it. So they construct the relationship in their favor. Who wouldn't? As the saying goes, let those who shall be deceived be deceived. 5. Declaration of the Trust. WEISS CONCISE TRUSTEE HANDBOok. The Declaration of Trust is the trust instrument that constitutes the trust. It has been noted in trust law that no technical expressions are required to create a valid declaration, so long as the words used to make clear the settlor's intent to create the trust or confer a benefit of some sort would be the best carried out in the form of trust. A trust instrument doesn't necessarily need to be a declaration either, for a trust may be, and often is, formed out of a simple agreement or even a will. But without an express trust, the declaration has been preferred since the beginnings of trusts under the common law of England, which otherwise shunned fictions of law. This is where attention to detail is most crucial, because in order to properly construe the intent of the settlor, the objects, property, and matter in which all is to be carried out must be set forth in unambiguous, precise language as to particularly create the express trust, and where the intent of the settlor is unclear, under equality, interpretation is required to construe the intent of the parties, and the trust may be deemed invalid, depending on the degree of ambiguity. However, when all is done properly, obviously there can be no lawful impairment of the obligation of contract. 6. Who do we declare to? By now this should be a given. However, because I have been asked this question a few times, and to be honest, this one stumped me for a while. See, in my case with the bank, no one would put their name to any letters, notices I received from them. So in this case, who do you declare it to? And here was my solution. Notice to agent, notice to principal, and notice to principal is notice to agent. Private and confidential. Time-sensitive document. Estoppel conditions will apply upon default. This is not to be used for any public purpose or display as it contains confidential commercial information. Applicable jointly and severally to all addressed parties, successors, nominees, and or assigns. Attention, senior officer, all officers, and or agents for the bank. Remember this. A trust is a private matter. Never, ever disclose information regarding the trust, i.e. the parties involved, the designation, the property, etc. in public. If you end up in court regarding a trust matter, only disclose to the judge in private chambers. Basically, the party you are designated to be the trustee who are considered the only party to whom you declare the trust. 7. When do you declare? If you remember, a trust relationship can be formed without a declaration, which I believe means that as soon as a relationship is formed, whether the parties know it has been created or not, means it has been automatically been formed. Therefore, if a trust automatically formed, then would you not only need to, at any time of your choosing, express the trust to take control of it, converting it now to an express trust under your control. Sounds simple? I hope so. Sometimes it sounds too simple to be true. You mean all I have to do is declare my position as seller to take control? Yup. How good is that? Can you modify/revoke a trust? The short answer is yes, absolutely. You can modify and revoke a trust. When you declare the trust, add something along the lines of, as seller of the express revocable or modifiable trust. You as a settler can declare, design, and create whatever lawful trust you want, in any way you want, and if you declare that it can be modified, then you can modify it. Signature 9. Signature qualifications. So what is in a signature? The short answer, everything. This is one thing that, since we haven't known about trust in the past, we didn't know about signature qualification. So what is signature qualification? It is another way to say it, restricting your signature. For example, John Doe, clean or unqualified, real man signature, will always be constructed to be trustee/strawman. John Doe, trustee, by trustee liable party, payer of the bills, signs the checks. John Doe, by beneficiary winner, picks up the disbursements. Authorized representative could be the trustee's assistant as the receiver of the document or the payer of the bills. 10. What can be declared trust property? Virtually anything may be held in trust. However, there are certain things which, given their innate traits recognized in law, make for a better subject matter, so to speak. In trust terminology, the property is known or referred to as the res. And yeah, that's about it. Once again, guys, I'll leave a link to some description box below, along with our email. You can email us at humongous@gmail.com for private consultation. And yeah, like, subscribe, and share. This is really important. And I'll see you guys in the next video. Bye, everyone.